morning, everyone. My name is Braxton Montier. I'm with UFLTV, and I'm here interviewing Dr. Kim Openshaw in the fourth installment of our custody evaluations interview. Dr. Openshaw, do you want to tell us a little bit about yourself? I know you've already spoken to everybody, but I think a refresher would be good.
Yeah, most will remember who I am, Braxton. So if they
Yes.
followed these through. So I'm going to make it real brief. I'm
Yeah.
retired at this point, but have been involved in custody evaluations for a period of my professional career. Over 25 years of it was dedicated to that, and more so to being an expert witness in courts, some in terms of evaluating custody evaluations, some in terms of doing custody evaluations, some in terms of dealing with criminal matters. So, that in mind, let's just go ahead and begin. They should know the rest about me. How's that?
Wonderful. All right,
Okay.
let's get into this.
So, we're talking about a matter of custody evaluations. And I guess a question comes in, why in the world are we talking about this, considering the fact that it's pretty well laid out in statute in terms of how these are done? And if you go and take any training, everybody kind of does the same thing. And what I've learned is that over the many years of doing this, that sometimes you have to look more in depth at what's going on and how you're going to do a custody evaluation. I do want to say that those who indicate that they're willing to do custody evaluation, that's certainly a necessary condition. It's not a sufficient condition, however. The sufficient condition is being able to look beyond and to see what may be missed if you're not really in tune with what you're doing. And that's basically what we're doing here. Some of what we'll talk about are things that everybody already knows. Some things I hope provoke some thought and maybe even some change in others. For instance, if we take this slide here, we look at this slide, a very simple slide, but relatively confusing if you ask me. I don't know about you. How do you see this slide? What pops out in your mind, Braxton, as you look at this slide?
Well, in the top right corner, we've got unless, but some of the letters are mixed up and orientated differently. And then, we've got no way evaluations that doesn't really seem to have a context in this.
Yeah. Okay. So how did you know that was unless?
Because I know how unless is spelled, and can kind of rearrange it in my head.
Okay, our brain, and that's a great point. I'm glad you pointed it out, because you see, our brain is able to reorganize things. It has a plasticity to it that allows us to learn, to grow, even if some part of our brain becomes damaged. It's interesting how that brain can remold itself and compensate for some of those things. And so you look at a word and you're not familiar with that, and our brain just automatically shifts it around and, oh, that's unless. And so it's a unique capability and very important when we're doing custody evaluations to be able to see sometimes what others may see as merely an error. Perhaps I hit the wrong key, I didn't pay attention to what I was doing, whatever the case may be. And are we ready to proceed? Now that's, everybody say, well, I'm here. Yeah, of course I'm ready to proceed. But then I ask the question, are we? And maybe I'm applying not so much to this interview as I'm talking about doing a custody evaluation. I go in and I've been called, I've been asked to do the evaluative, and I look at this and I say, well, am I ready to proceed? Well, of course I am. Well, but am I? Am I really familiar enough with what's going to happen and what I need to look for to proceed? Okay. Now, the third thing about this, and all of these have to do some with what this presentation is about, no way evaluations. And you're absolutely right. There's no context. So let me add a little bit to that. No way evaluations. There's sometimes in no way am I going to do an evaluation. And just because I accept the fact that I'm going to do an evaluation, I have to look at this and say, there's no way I'm going to do this evaluation because there are too many roadblocks that need to be looked at.
Yeah, there's no reason to do the checklist on a plane if the plane's currently on fire. There's no way that plane is getting off the ground.
Yeah, really. I
Yeah.
wonder sometimes about these planes where their wings are frozen and they're still spraying that stuff on. I don't know if I want to be on one of those planes.
Yeah, that would be fair.
So, but too often it's just easy to pass the buck. And passing the buck means it might be a judge passing the buck and saying, just go do this. But maybe the judge might have an opportunity and take the time to look at this situation before such is ordered. Sometimes it's the attorneys that pass the buck and send it to the courts and say, put us on an evaluator. Sometimes it's the parties, one or both of them, that pass the buck. And sometimes passing the buck means just passing it off and going on. And sometimes passing the buck means not looking at factors that may not help us focus on the best interests of the child.
Yeah.
So it's essential that certain situations be carefully examined. In other words, whenever you're asked to do a custody evaluation, consider looking carefully at the facts. The facts aren't there, you need to get them. Look at them.
Yeah, the last thing you would want is to pay all of the money and go through all of the hassle of a custody evaluation just for one person who's supposed to help in this the complex process of a custody evaluation, one of the pillars of it, to just be asleep at the wheel.
Yeah, really. So with careful evaluation, we may determine no evaluation be initiated. This is the case in any of the following conditions, at least in my opinion, and this is not an all-exclusive list. There may be others, but let's just look at a few of them. Now, I want you to notice that each one of these begins with the word evidence. Okay?
Yes, because all too often people will say, well, there's an allegation. It's like, okay, they could be lying, that could just be untrue. But if there's actual factual evidence that can be proven, then that is something that needs to be taken into consideration.
Yes, definitely so. For instance, and as we go through these, what you're saying, Braxton, is right. At times, allegations of these things come out, and it sways the determination. Now, you notice as we go through how many of these are either neglected or how many of these fall into some kind of common allegation. So, evidence that there has been and continues to be physical, sexual, or emotional abuse of that nature.
Those are allegations that are often brought up. It's one of the easiest piles of mud to sling at your ex. To say, well, they're abusing the kids. It's like, is there actual proof that they're abusing the kids?
Yeah.
You don't know.
Well, that's right. We don't know. And so if I go in with that, I go in with a mindset already determined that there's a problem here. Evidence that past abusive behavior, physical, sexual, or emotional, has not been resolved, reconciled, and reunification has been successfully integrated in the relationship. Now, in my years of working with those who sexually offend, what I found is there are sexual offenders, those who really are tied up in the enjoyment, so to speak, of sexually offending. There are psychopathic, they're sociopathic, they offend for their own sense of gratification. And there are those who got into a situation and sexually acted out, and through the course of therapy have, with the individual who was sexually offended upon, resolved, reconciled, and reunified with that person. Now, resolved, reconciled, we pretty well understand what that means. Reunification, though, has a broad range. There may be reunification in terms of, okay, we can be okay with each other, but it isn't reunification to where I want you as a close associate, a parent loving me. I'm just not at that point. And those
Yeah.
things have to be understood. So there are two things, offenders and offending.
Yeah.
Okay?
It could be like you were saying, it could be the difference between like, look, as if I were the child in the situation, I would be like, okay, I understand that, my dad, there was a lot of factors, and in this example, he, raised his fist, beat me once. Okay, he's very sorry, but maybe I could walk past that and think, you know what, it was a one-off, it was a bad time. Or maybe the kid isn't comfortable, and it's just like, you know what, you did it once, that was too much. Once
Mhm.
was too many times. And so I can be fine with you, but we're not going to have the same kind of relationship. There will always be some sort of distance, and we need to be comfortable with that.
Yes, yes, very well said. And what I find too is sometimes it isn't the child, it's the other party, who can't get past this. And so they engage in behaviors of what the next one is kind of going to look at is alienating the child, interfering with it, believing and not forgiving. Now, forgiving doesn't mean to forget and to become lackadaisical. It merely means you've got to allow things to move forward.
Yeah, because that's how you get stymied in place, and that's how you stop moving forward. Because
Yeah,
you can definitely see, I could definitely see how somebody would accidentally raise their fist, or in a moment of weakness accidentally do something out of character for themselves, and then spend the rest of their days regretting it, just trying
yeah.
to make up for it, um, because they can't move on and accept the new situation.
Yeah, and I like what you said, it's they spend the rest of their days attempting to make up for it and can't go on.
Yeah.
And if you're in that kind of a position, that's like living in crap all the time.
Yeah, it's a purgatory of your own making.
It certainly is. Okay, so let's look at some of these going on. Evidence that the other party's ensuing actions that are consistent with parental alienation, which means you got to be aware of what those actions might be. Evidence that the other party's ensuing actions that are indicative of or consistent with parental alienation or parental estrangement. Okay,
Yeah.
so let's go on and just see these. And evidence of sociopathic or psychopathic behavior that continues to be manifest. And those are really two different types of uh, psychopathy and sociopathy in terms of their presentation. And so, again, we need to be aware of those kinds of presentations as we are in terms of uh, different types of personality disorders that interfere with our ability to interact well with someone else. Evidence that the other party has or has not addressed a personality disorder. Evidence of a long-term substance abuse disorder that has not changed. Uh, it's not in remission at all. Evidence that of behavior that would put the child in a state of danger and disregard. For instance, a person who is alcoholic, but says they haven't got that they aren't an alcoholic, but every time you find them in the car with the children, they're under the influence of alcohol.
Yeah, they've got an open beer in the cup holder. It's like, well, this is just, one, or, they'll make up whatever excuse they need to make up.
Yeah. Well, and
Yeah.
like I said, this is not an all-inclusive list, but I think
Yeah.
the key point is evidence of. If you're going to make an allegation and it's going to become a part of the custody evaluation, there needs to be evidence of this particular allegation. So this is really not an allegation, but determined to be true in fact.
Yeah. One of the easiest things that people do to take cheap shots is, oh, my spouse is a narcissist, or they're bipolar, or they claim they have some sort of personality disorder. Um, when in reality, that may not be true. You might just not like the way the person is treating you. There could
Mhm.
be nothing wrong with the person. Um, but also, like we were talking about earlier, if they have like a documented problem and they are not getting any kind of treatment, there's no sort of management around it, and they're just kind of letting it dictate how they act, and then expecting their partner to pick up the pieces afterwards,
Mhm.
that would be something that I would think would be important to the custody evaluation.
And you're absolutely right. For instance, a person depressed, we use that against them sometimes. Well, they're depressed. Well, if they're depressed consistently, keeping a child home from school to care for them, take care of them, and there's no change, well, that's a concern. On the
Yeah.
other hand, just because a person has been diagnosed with depression doesn't mean that that's a problem that prevents them from being a good parent.
Yeah, if the person has depression and they're managing it, whether or not it's with therapy or with medication or however specifically they need to manage it, that doesn't mean that they're a bad parent just because they have a mental issue. It just means that there's somebody who has a problem who just needs to get it addressed. And if they're getting it addressed and they're receiving the care that they need, you wouldn't try to take the kids away from a diabetic just because they need insulin.
Yeah, and I think it shows a great deal of courage and strength on the part of a person to recognize that something's wrong and to seek out help. And so
Absolutely.
that really needs to be considered. Okay, so like I said, not an all-encompassing list, but certainly some. Well, the question then becomes, what do we have to discuss? Because basically, we could go and we could look at the codes here. I've listed a few of the codes down, 81-9-204, Rule 4.903, that deals with child custodies and things of that matter. So why even look at that? Well, I really appreciate the time and effort that's gone into create a standard. To me, it's a guide. It shouldn't be said that you can't look beyond and consider other factors. Because other words, I'm just kind of going down a list, a checkoff list. And I think anybody can do that.
Yeah, there's no kind of expertise that goes into it because,
No.
yeah,
And just because I can rattle off the list of things to be done as an evaluator, what goes into an evaluation, what the judge wants to read, doesn't mean that I am taking a good stand in terms of clinically looking at this particular issue.
Oh yeah, and especially like there is a standard. If the standard isn't met, that means that you failed. That also means that that's the minimum that you should meet. And
And,
if you're actually evaluating, you should kind of strive a little bit farther than just the minimum.
and I think you're absolutely right. It is a minimum standard. It is not the gold standard.
Yeah,
Okay?
yeah,
So the gold standard says, I really look above and beyond and create a recommendation on behalf of the well-being of the child, wherever that takes me. And I really believe, at least I found, judges really appreciate those who take the time to go, above and beyond in what they do. So we want to look and transcend beyond kind of what I call the mundane and the obvious. And to do that really requires that we take a position of critical thinking. So let's kind of look at these. Those involved have to set aside their emotionally ingrained ideas and learn a new way of thinking. That's what critical thinking is all about. And interestingly, learning a new way about thinking in each case is really important. If you see a custody evaluation as an ABC process, you are in the wrong business.
yeah.
Because
If you're going through the list, just going, okay, these are the child custody factors, check box, check box, check box. You're not really evaluating. You're
no,
just looking for something.
that's right. And to evaluate means I have to have a critical thinking ability because every single situation is a different situation. Uh, every person who comes in with a complaint of being depressed must be looked at in their own personal context. They are a person of their own right. They don't have an ABC. When I was a young person um, learning about child development, Dr. Spock was not the Dr. Spock, with this, but Dr. Spock was the guru pediatrician of the world, so to speak. But his philosophy was an ABC philosophy. You have a child, you treat them all A, B, C, and you get a good child. Well, okay, maybe if that were the case for some, but that would assume that every child is the same. And that's not the case. And of course, then Barry Brazelton came in after Dr. Spock as the guru of the pediatrician world. And he kind of turned that upside down and basically said, no, there is no ABC. Each child has to be looked at and treated and helped developed in their own right. And so it is with custody evaluation. Each must be looked at in its own right. So there are questions, I believe, that help us begin to formulate a thinking about how we think and about the people that we're going to be looking at. These are a priori questions. In other words, questions that are established before we really get going. So let's define just for a minute critical thinking, and then we'll look at a priori questions. Critical thinking is a thinking that steps outside of logic and begins to look very closely at some of the abstract. It takes different pieces and has an analyzing component to it. It has the ability to step outside of what you analyze and to look into and look out of. It is a unique form of thinking. There are dozens of critical thinking definitions if someone wants to go to the internet and look them up. But there are attributes associated with being a critical thinker. And one is, like I said, to be able to step out of your own body, your own conceived perception of something and look at it from different angles.
Yeah, because that's where the actual evaluating happens. Otherwise, you've just gathered facts and have left interpretation to other people.
Yeah, and you're assuming that the facts are are true in their own right, and that's not necessarily the case. So a priori just means, if I'm going to begin a custody evaluation, and later on I'm going to talk about how they're selected, but let's say I've been selected as the evaluator, there's certain questions that come to my mind that I want to ask before I even begin. Maybe these questions may prevent a custody evaluation. Now, as an evaluator, I've learned that if I can prevent an evaluation while, it costs me the $50,000 to do an evaluation, uh, it helps a child because I have minimized the animosity and the adversity that could be created.
Yeah, because when the custody evaluator comes in, I imagine everybody is kind of putting on this front of trying to be 110% of themselves in the way that they would to get the outcome that they would like. So they're really trying to put their best foot forward, and I can see how for a child, if that's not normal, they would be a little kind of upset about that. They would try to figure out what's going on. I know if I were that kid, I would have questions.
Yeah, I would too. They're probably looking and say, where is this person coming from here?
Yeah, yeah. Why has my dad not screamed at me or my mom not screamed at me? It's 2:30. Usually they're home by now and have screamed at me.
Yeah.
Uh,
Well, and you bring up a point that the evaluating reader has to be cognizant of, and that is when you first meet somebody, they're going to put their best self forward. Now, their best self forward doesn't mean that that's their true self. It merely means it's how they have conceived they need to present themselves to a certain person. And we all do that, in a first time
yeah,
meeting of someone, we don't start off with a bad side or a critical side of, oh gosh, your hair really looks crazy. I think it's really stupid. Or why have you guys got a beard? You're trying to be Sigmund Freud. You know, we put forth this really positive, wow, you look really cool today, you know. So, okay, so a request has been initiated. Attorneys meet with the clients and we begin engaging the process. And we're going to look at these steps a little bit more closely as we go through here. First of all, we have to realize that when people come in, and not only are they putting forth their best self, they're kind of holding their breath. I don't know if you've seen this, but I've seen it. They're kind of holding their breath because they're holding back the animosity they have towards this other person. This other person is trying to take away from them, not so much maybe their children, but they're taking away their financial resource to them. And so there's
yeah.
a lot of anger in there. And it's kind of like they're smiling, but they're biting their teeth.
Yeah, a very strained kind of forced smile, and you can see the muscles in their face just so tight. So like you're thinking they're gonna crack a molar or something.
Yeah, very much so. You ought to have a dentist on retainer, of course, right?
Yeah,
Well, the thing of it is we have this idea about logic and emotion, and I've posed this to classes of hundreds of students, and I typically get the same result. And that is, if we have uh, logic and we set it at 100% as it is on this scale here, and emotion at 0, so I'm just a robot, so to speak, there is a thought that as I increase emotion one step, I decrease logic by a step. In other words, there's a one-to-one correspondence in increasing emotion while decreasing logic. That's the way most people think that happens. The reality of it, Braxton, is that it doesn't take a lot of emotion to interfere with logic. And so when someone comes in and they are angry and they're saying, I want a custody evaluation, the first thing I have to ask myself is this coming from logic or is it coming from a balanced logic emotion? Or is this coming from an emotional status that has now interfered with their logic? Most of the people I've seen initially begin with just minimal logic and tremendous emotion. What has your experience been like?
Well, a lot of the people that I've talked to or who have gone through divorces, uh, immediately the thing that they seem most concerned about is how they have been hurt or betrayed or
Mhm.
stabbed in the back. And so they're really worried about themselves and their feelings. There's not a lot of people that are like, well, she cheated on me. I guess we should start filing paperwork, and just
Yeah.
goes about their day, just no feeling whatsoever. Um, a lot of people get kind of caught up in the he said, she said. They're not worried about facts or logic. They're thinking, I can hurt you this way. So I will get the custody evaluator on my side, or I'll get the lawyer or the judge or whoever kind of art is evaluating or arbitrating at the time. I'll get them on my side. They'll see what kind of a terrible person you are. And then they'll realize that I've been a saint through this process having to deal with you, and they'll cut me some slack.
Mhm. Yeah, yeah. There's all of these attempts to bias the
Hmm.
process and the people who are involved in the process. Well, but if I know that, I need to begin creating an atmosphere where the person can eventually, even if they need to, you know, share their emotions and share their anger, I don't really care as long as I can begin to create an atmosphere in where that person feels safe. I'm not offended by what they say. Oh, you're just a jerk, here by the court, you're that, whatever it is.
Yeah, how
I,
could you understand my position? You're just appointed by the court,
yeah.
kind of.
Have you ever gone through this?
Yeah,
I've
and
never been asked that, but I've certainly been asked, have you ever gone through this? No, I haven't gone through it. Well, how can you know what I'm experiencing? Well,
yeah, how can you truly understand whether or not this was an accident or on purpose if you've
yeah,
never been in my situation?
right. Well, I can do that by you helping me understand. If I can listen and you can help me understand, then I can be a better resource to you. And of course, I'm not doing it just to one person. It has to be balanced. I have to create that safe haven, so to speak, for both people. And it's even more beneficial if I get the attorneys doing the same thing, that there's a safe haven and and that they send out this message to the parties that, you know, yes, I'm here to represent you. At the same time, you have to understand, and this is the transparency kind of piece here, you have to understand that I need to focus on the best interest of the child as well. And
Mm. there can be a lot of friction that comes up when somebody doesn't want to admit that maybe the best interest of the child is a change in custody or a something other than what that person wants.
That's right. And in fact, they may even fire you,
Yeah.
you
Yeah.
know, because there are those like those seeking doctors who will give them prescriptions that they want. Uh, there's no difference in people going out and seeking an attorney who will give them what they want. And
Yes. Absolutely.
if it means to destroy the other person and they can find someone, well, that's great. But I'm glad there are not many who are like that, who will accept that. Okay,
Yeah.
so we need to take this into consideration here. Important to recognize and communicate. This role of diversity has to be, transparent. I've often seen it implied, but more importantly, it's important to be, you know, expounded on. That I'm here to represent you and to make sure that there is a fair shake in the finances and the share of property and things like that, and that the best interest of the child is preserved. And it may or it may not be the way you would like it to be. And that's
Yeah.
a hard position to take, but essential.
Well, absolutely. Because they could be the nicest people in the world, but if they're not providing, the best, if they're not actively fostering the best interests of the child or the children, then it doesn't matter how nice they are.
That's for sure. So the attorneys meet with the clients, and that's probably the first place it all begins. And so right up front, the amount of adversity, the nature of the safe haven, the element of transparency really begins right there before an evaluator is even selected or brought into the situation. So as they're engaging this process and they're formalizing the decision, we come back to this a priori question. And I believe that these questions are important to ask right at the beginning, even by the attorneys. As an evaluator, I would hope that was done, and I would repeat it anyway. And I really ask that they be videoed, not just recorded, but videoed. But now, in order to do that, this safe haven has to be there. And if I'm going to video someone, I need to help them be comfortable with that. You know, I've been asked, I won't say by who, but I was asked about, should we, record and video children because, gee, are we going to get what we want? And the answer to that is it depends on how that has been set up. Having trained
Yes.
students for, 3 decades and doing it by teaching them how to work in the context of others watching them behind the class. And whether it's a supervisor back there or other students watching, if someone comes in, the first concern they have is, oh, who's going to be behind the glass? Well, we help them acclimate to that. We show them the cameras where they are. We actually take them behind the one-way glass and show them what that's there. Talk with them about who's going to be there. And you know what? It doesn't take a long time before they are really acting as they would normally act. The
Yeah.
front is taken off.
Yeah. If you remove the mystery from it and you explain the process and, the person who is being questioned for, uh, you know, to use that term, the person who's being observed, um, if there's no mystery behind what's happening, they understand everything. They know who's there, what, I know I would be a lot more comfortable if somebody explained the whole process to me and then we did it, as opposed to just jumping in blind.
Yes. Well, and these a priori questions are not the easiest questions to ask or answer, as you'll see. And so that context has to be created. Well, now a priori has two meanings. One, these are important questions to ask because to me they give me a lot of information as I move into an evaluation. But a priori is that they're designed in a way to help people become more calmly and willing to answer the questions. So let's kind of look at some of these questions here. These are important questions, and there are a variety of a priori questions. You can create them as you want to. A couple of them, I think, are essential as you look through them. So there are a series of questions that have been formed and they're conceived of beforehand. That's what it means a priori. They're conceived beforehand. They're determined from reasoning that's based on experience of a self-evident nature that enhances the ability to predict a given outcome, and as such are given a priority over other questions. So to me, these are questions that are more important initially than to ask the question, well, okay, so tell me about why you want a custody evaluation. Now let's look at some of these questions. Okay, so in what custodial context? I'm asking this of both parties, and what's even interesting is if I had the parties alone, I would ask them to write down their answers and then share them. But if I'm in an attorney's office and we're doing this, and I would have the attorneys start it here, in what custodial context would the developmental needs of the child, and I use the word singular, knowing that it could be plural, and so you're talking about multiple children of various ages, best be met? And how did you come to that decision? Now, that's a really interesting question. It's one that begins to have them think, because they're coming in immediately saying, I am the best parent. I can best do this for the children. Therefore, this is what needs to happen. They're basically telling us. And what I'm doing is I'm asking them to think about how they came to that decision. So how would this custodial relationship serve in meeting these needs? So they share with me, okay, this child is 2, and these are the developmental needs, physically, intellectually, emotionally, socially, spiritually. And over here, these are those needs on those 5 dimensions. How would this custodial arrangement facilitate those? And what would be the pros and the cons of such an arrangement? Now, this is time consuming, Braxton. It isn't something that happens right off. And
Yeah,
again, like I said,
this isn't something that you should answer in 2 minutes. This is something that you should probably take as much time as you need to answer.
that's right. And sometimes you might say, now, I don't want you to answer right now. I want you to take 10 minutes, think about it. I'm going to walk out and here's some paper. Why don't you write down the answers to that question? And that question would be on that paper.
Yeah.
Okay. Now I've got them sharing that information to me, which is really, it gives me a lot of good information. And I'm recording it because when I see their body language as they're expressing it to me, their body language tells me sometimes something very different than what I'm getting from what they're sharing with me. Example.
Yeah.
I was sitting in a situation one time and the couple were, I don't understand where she's coming from. I love her. I really love her. And I have to stop and I have to ask the person, okay, so you're saying to me that you really love her. And at the same time, I don't use but, okay? So I use and at the same time, you're shaking your head. No, I'm confused. Which one of these am I to take as your position? You,
Yeah, because it also kind of goes back to the idea of video recording as opposed to just audio recording,
Mhm.
because there's a lot of communication that could be missed if you don't have the body language of how the person responded or how the question was asked. Um, but like you're saying, if you ask a person, the person's saying, "Well, I love this woman. I love her," and they're shaking their head no, they're very closed off.
Mhm.
Are you sure?
Yeah. Well, the body doesn't lie. That's
Yeah.
really an important part of it. You know, that's why we talk about these clenched teeth you were talking, you shared about and things like that. Okay. If a Then the second question, if a custody was awarded different than what you would desire, how would you approach this order and make it work in the best interest of the child? What would be your expectation of the other party?
It could be very revealing on how they would answer that. If they
Mhm.
go, well, it's not all, until the whole process has gone through, like, I appeal the decision or I try to modify or I petition the court again. Um, can really tell you a lot about how this person is actually seeing the whole situation as opposed to, um, well, if you didn't get your way, how would you make it work? And if somebody was said, well, I would try to follow, I would try to be the best parent I could, and I'd try to, help my kid reach their goals. That those two answers would, I think, reveal a lot about the kind of person that they are.
It does. It tells me whether or not this person is really willing to co-parent. If the child's interest really is predominant over your interest.
Yeah, and it goes back to the critical thinking around the logic and emotion. Because if the person just responds, well, I think I know best, as opposed to actually sitting down, thinking about their answer, and then essentially just showing their work. It's like, no, this is the schedule. I can provide care these days. So I think it would be best if on those days I provided care. Like,
Yeah,
yeah,
yeah, these questions are very revealing. Let's go to this third one. How is it that previous to or in mediation, the two of you did not reach agreement governing how to meet the child's developmental needs? Now, this is an interesting one because these first two begin to set the person up. If the person
hmm
really is beginning to think, then they start taking some responsibility what happened in the mediation. Other words, they will come back with, well, I've tried to tell you, if John Doe over here or if Sally over here would have done this, we wouldn't be in this situation. But I take that just a little bit further. And as I've talked about that, and again, each one of these I like to give them time to think about. I don't want an immediate response because that's a knee-jerk response. It's kind of like going into my orthopedic person. He says, "Okay, let me tap your knee," and wow, I end up
yeah,
thickening. So there's a knee-jerk response. Well, as you consider the previous question, during the mediation process, what did you do or what did you not do that prevented an agreement that would promote the equitable sharing of the responsibility for meeting the child's developmental needs with the other party? Now that's kind of wordy, but I did that on purpose to give you a point here. So now What would you think, Braxton, if you were now being asked that question and you were one of the people that comes through you or Attorney Johnson's door?
You, a lot of people would think that, well, I was being reasonable and they were the ones that were kind of off base. But if you dig
Mhm.
down a little bit deeper, you, when you reach an agreement, both sides are supposed to feel a little cheated. I know that that's kind of, that's something everybody has heard. But
Mhm.
really, if you're thinking about taking responsibility for the situation, and you're really thinking about whether or not you can negotiate on this, it doesn't matter if you have a strong position or a weak position, because you need to think about what's best for the child, or what's best for the both of you to get the divorce settled. If you're too angry about actually reaching a resolution and you would prefer just to fight, that's not helpful. And you've wasted your time, your money, your spouse's time and money, and everybody else's.
And as an evaluator, if I get here and the people are like that, they are still blaming, this is one of those places where I would pause on evaluation and I'd say we need some anger management in here. Okay, so last one is what must occur for the two of you to mutually agree on a co-parenting process. And notice as these questions are asked, notice this number 5, why a safe haven environment is so essential. Okay, they've got to be
Yeah,
able to open up. Okay,
they're not going to tell you the truth. You won't get it. It's going to be dentistry to pull it out of them, and
right.
it'll make the whole process a lot harder.
But can you also see in that process that if those people can begin to take responsibility,
Yeah,
how we can bring it back into a mediation process that may be
yeah,
much more successful to the outcome for the child and to the parents than any evaluation may do.
yeah. Absolutely. If they feel comfortable enough to actually critically think about what's going on, they kind of stop that fight or flight. Oh, I've been betrayed. This person has sprung a divorce on me, and now I have to go through this whole process. And if they
Uh,
can remove kind of the really the emotion out of it, not that they need to be all logic, but if they can just take a step back and really critically think, I think a lot of people will realize that they're really not as far apart as they think. Like
yes,
they could settle this. They could mediate this effectively.
and I agree. And of course, some of them are still going to come to the point of needing an order by the court. You know, they
Yeah,
still want an evaluation. They still want a divorce and they want to do it in the best interest of the child, whether it be really the best interest of the child or themselves. So let's talk then about selecting an evaluator. I think there's some steps that I believe would be important in this process. You know, one, the attorneys need to work in harmony with one another to identify a pool of candidates. Now, if I know the process correctly, you know, the request goes to the judge has a pool of candidates and he says, okay, here's you know, the person going to be the evaluator, and he gives them the exhortation in terms of what their responsibilities are, and hopefully, you know, what the first part of evaluation is going to do is bring them to an agreement, a settlement, without a full custody evaluation being done. My experience has been that if we get to this point, they have given up the opportunity to mediate it in mediation. They have given up the opportunity to mediate it when they've looked at their own point of responsibilities and are still saying, I want an evaluation. you're not going to bring a settlement to the court. You're going to be doing a full evaluation. So the selection of an evaluator becomes a very important process. So this is a way, I think, and it's a little out of the ordinary. Like I said, we are not going to deal with the mundane and the obvious. We're going to do something out of the ordinary. So one, the attorneys are going to work in harmony to create a pool of candidates. Um, they're going to bring their qualifications together and share them with the parties. Now, if the attorneys are willing to do this, I find this most helpful. If the attorneys work to pull the the pool of evaluators' names together and look at their qualifications, and then the attorneys bring that into the parties, they're all in the same room there, and the attorneys and the candidates work in harmony to select two or three. And they say, okay, here are the attorneys, or excuse me, here are the pool of candidates. Here are the that we think would be good for this process, and here are their qualifications. And the individuals themselves really look through the qualifications, and the two of them have it right there. The attorneys are here, they're doing it around a table, and then they select, two or three to interview. And so now the attorneys and the parties, and one at a time, an evaluator comes in and are actually being interviewed by the parties.
So they can both pick somebody that they're comfortable with and really start that safe haven space off really well.
Exactly. And so they're working together, and they see that the attorneys are not in opposition to one another over this matter. They may have difference of feelings in terms of the finances and things like that. But over the custody of the child, they are not indifference with one another. And they're working to come up with some harmonious thing. So they're working through getting this relationship. But what this does, I believe, is one, it empowers the parties in their decision making and selection, something that probably hasn't been done in their relationship for a long time.
Yeah.
Second of all, it humanizes the process. In other words, rather than a mechanical, here they are, this is an order that this person is going to do this. It involves them and humanizes it. It says here, you're important in this process too. Third, it reduces the sterility of the process, which in turn can facilitate a more effective evaluator party-child relationship. Now, I mean the sterility. If we've got the two parties out on their own, and even though they come to an agreement, they say, okay, these look like the best, doesn't mean, that it has become an open and transparent process. It's like, I'm the evaluator, now you've chosen me, I'm going to go about this. And it loses it loses the humanness of it, it loses the safe haven nature of it, and it loses the transparency. So, another thing, it decreases the adversarial context, demonstrating that the attorneys are there to facilitate and not damage family relations. Now, I'm not saying damage family relations that they're still not going to go through with the divorce, but they're not there to damage the children and the family relation, that the children need both parents. Okay.
Yeah, a lot of people forget that a divorce lawyer is there to help you get divorced. They're
Yes.
there to help you dissolve the marriage. There are rules that have to be followed. There's a legal process to it. But if you're in tune with that process and you've been told it's like you said, it humanizes it. It changes it from this order that's been given to you from on high to, well, this is part of the process. We need to go through this. So let's find the one that works for us.
Yeah, yes. And I think it increases the probability that a settlement conference will be successful if
Oh,
we
absolutely.
bring them
And
into the process.
anything that can shorten the gap between the two people absolutely would help settlement.
Okay. Okay, so let's say I'm one of the parties and I want to begin looking at these two or three evaluators. What am I going to look for? There's some character traits that I think are really important. An unbiased perception couched in an attitude of empathic compassion with neutrality that allows for discussion, discovery, and non-judgmental confrontation. Now, that's a mouthful, but I've got to be
Yes.
unbiased. And, if one party's paying for all of this, I can say I'm going to be unbiased, but there's always this underlying fear that, oh, that person's really going to be mad at me if I don't lean in their direction. So,
Well, yeah, you're human. You have to be. That's just what every evaluator is going to face. It's always going to be that human element of, well, this person may just be mad at me because they paid for something that didn't go their way.
yeah, yeah.
That
So an unbiased perception needs to be created, and that's hard sometimes. There has to be an attitude of empathic compassion with neutrality. Now, I have to be able to listen to those people and hear what they're saying. Okay, I have to be compassionate to whether, even to their anger, I have to be compassionate and understand where that anger is coming from without putting it out on someone else, because it facilitates discussion with the person, discovery, and non-judgmental confrontation. I can say, now, I'm hearing this. Let's just take a moment and take a breather and talk with me now about what you're saying. What do you really want me to hear?
Yeah, because they might just get too caught up in the emotion of retelling something that happened or explaining the circumstance, when in reality, they just want to get across a completely different point.
Exactly. And of course, we want someone who is transparent. If I go in with this attitude of, I am the evaluator, don't ask me questions. Now, I'm not saying divulge your life history, but you do have to be transparent. Yes, this is what I'm doing. This is where I am. This is where we're going. I don't have to share all of the findings or my concerns, because my concerns need to be addressed in this discussion, discovery, and non-judgmental confrontation. And transparency continues. Okay. The resume that the person brings in, and I really encourage them to do that, verifies competence. Now, I know people can pad their resumes. I've looked at enough resumes and hiring people at the university to know padding of a resume. But we want to be able to look at that in a way where they show competence in diagnostic assessment, their ability to ferret out active parental alienation and estrangement, and in-depth psychopathology, including many of those things that fall in that evidence box that we talked about, and willingness to stop the evaluation if these issues necessitate intervention. And that
Yeah,
has to be upfront with the people. I will stop this if any of this is noted.
yeah, absolutely. That if you wouldn't want somebody who just go, well, you paid me, I'm just going to check everything off. That they're not somebody who's there to just get paid. You want somebody who is actually competent and can do the job and is willing to do the job well.
Yeah.
There's a difference between like technically I'm qualified to do this and I can do this and I know how to do this and I'm willing to actually do a good job.
Yes. Yes. Okay. So, and the ability to utilize appropriate diagnostic tests that can be and are clinically verified. Now, when I get to this point, I begin thinking, who's being called to be well, let me finish. I apologize. Let me finish going in this. In-depth understanding of human development, and you can read these things. Willingness to go the extra mile. Now, that's willingness to go above and beyond what you're asked to do. And it may be I have to spend some really an enormous amount of time with the parties, getting them comfortable in a particular context. For instance, if I want to see them behind one-way glass and have them interact, give them something and record them, I need to spend time helping them acclimate to that context. A child, the same way. I need to be able to work effectively. I need to spend time. So if I'm doing this part-time or I've got another business that I'm doing, I'm not saying you can't do, I'm just saying it's going to be more difficult if I can't put my soul and heart into the evaluation. Okay. Well, part of transparency is talking about a timeline because you go in and the judge may say, okay, I want this in 2 months. They need to understand that there is a timeline. Now, I have to stay on top of the timeline. If there's going to be a variation in that timeline, I need to discuss it with them. I have to be transparent. It can't be because, oh, well, I have other clients that I'm working with. I don't think that's responsible. Now, others may say that's crazy, Kim, but I really don't think that's responsible. If I'm taking on evaluation and taking on more evaluations than I really can do, and it interferes with the timeline, I just don't think that's responsible. I don't know. What do you think, Braxton?
Well, if the person, the custody evaluator who is taking on more than they can handle, I do think that it is irresponsible because it's not them who has to live with the outcome of the evaluation. It's the people that they're evaluating. The court's going to rely on this custody evaluation, whether or not, you did a good job is something that the lawyers can argue. But the custody evaluation is going to hold weight. And if you don't do a good job, or you take longer than you told them that you would, or you aren't transparent in the process, it kind of erodes the safe haven that you worked hard to create. It erodes the trust that both parties have put in you to be an effective evaluator. Because the last thing I would want if I were a somebody requesting a custody evaluation would be to say, hey, can we get this evaluation? They say, yeah. We meet a couple of times and then they go, okay. And I don't talk to that person for a year and a half. And then out of the blue, I get an evaluation report. It's like, okay, well, it's been a year and a half. A whole bunch of stuff has changed. Life has moved on. We settled the case before the evaluator was done, or you know something like that. But we just every time we tried to follow up with this person, they just gave us the runaround. So I think it would be irresponsible to not be transparent about the process.
Yes, and I think, when you're not, I believe you step in a puddle of moral and ethical concerns.
Yes.
And so when you're ready to formalize this, you need to help people understand, as this is showing, the presentation of the objectives, the clarification of the data gathering, discussion of their rights and responsibilities, defining the limits of confidentiality and the formalization. That takes some time, and you need to help them understand this timeline. And you yourself need to be aware and follow through with that. So the
Absolutely.
evaluation begins. Sorry, I cut you off.
No, I was just agreeing with you.
Okay, so the evaluation begins. First of all, you've got to evaluate the parties, okay? So I separate, if I'm doing an evaluation, I separate this out and I begin with the parties. And, we've got their reported history, their what we call a biopsychosocial history, their biological history in terms of medical issues coming up, any problems biologically, physiologically that they have going on that may interfere with their ability to perform parenting behavior, looking at their psychological nature, so their clinical symptoms, if there are any personality disorders, if there are any. We're looking at their social system. Are they introverts? Are they people who are so extroverted? We get a good perspective of that. So that's a reported. And so we have a perceived biopsychosocial interviews. We get those two biopsychosocial interviews. And that's where if we begin looking and say, in my practice, if I had a social worker, social workers are typically well trained in doing psychosocial evaluations. They could be gathering that. Psychologists are really good at doing diagnostics. And marriage and family therapists are well skilled in terms of doing systems analysis. What if the three joined together? Well, I believe it would add a lot because you're getting this information that allows the evaluator to examine congruence of their perception. And so we look at crisscross data, which I don't think is commonly done. We have their perception of their self and we have their perception of the other person. Now, likewise, we have the perception of the self from the other person and the perception of the other by the other person. Now I can begin to look and see, well, what is the congruence? This crisscross data is very interesting and it gives me more to examine because if the perception of that I give you is not in harmony with the perception that the other person has reported of me, you're going to want to look at that. Remember, we want evidence-based. We don't want assumptions. We don't want allegations. We want evidence-based.
Yeah.
And this is a great way to begin looking more in depth. Okay. Now, if we need to do evaluations out of those psychosocial histories, we get the diagnostic assessment information ready. We may do an OQ45. An OQ45 is just, an overall type of evaluation of the person's well-being, but it has some very interesting scales in it. The MMPI, the Milan, the TJTA. The thing I like about the TJTA is it looks at the relationship across multiple dimensions and it has that crisscross component to it. Okay. And some people go out and collect collateral data from friends, diminished friends, schools, employers. What I mean by diminished friends, I'm talking about when you get a divorce. Isn't it funny what happens to your friendship pool?
Yeah, people feel they need to choose sides, and so they'll either cut you off or fall in line behind you, and they'll pick a side. It's like, well, we can't be with we can't hang out with Terry anymore because we're friends with Alice, and Alice is who we chose.
Yeah.
So
And so I put down here questionable data at best. I wonder when I gather that data if it's any good. Uh, if there's school information, maybe the actual school, actual employer information may be important. But honestly, that becomes very questionable data. And if I rely a lot on that, that's not too healthy. But when I use these tests here, if I rely solely on the data from the tests, then I have inappropriately used the test. Tests are only to give us a point to go in and clinically examine. If someone on a Beck depression inventory fills out the questions that suggest that they have extreme depression, and I don't go in and analyze that and really see if this doesn't happen to be a specific depression or symptomatic presentation because of the condition they're in at that moment in time, then I'm giving a diagnostic conclusion without clinically evaluating the data. Not
Yeah.
everyone is qualified to do, for instance, the MMPI and the Milan or the TJTA. They need to be, they need to have special training. Um, that was one I was questioned on because I don't have a psychologist license. I chose not to license in that. I figured 2 licenses are sufficient, but I was trained in it and had some very interesting experiences with uh, those who have actually done creation of it, custody evaluation, where my qualifications were not questioned at all.
Hmm.
So if you're trained adequately, but honestly, these are areas that are really good that a psychologist does. Okay, so I take those information. There has to be a confirmatory interview, psycho-emotional reevaluation. And again, unless this information has some value to it, first of all, I wouldn't waste my time getting it. Second of all, I would consider if I did get it, whether it really had any meaning. And thirdly, you have to understand that if I say to you, yeah, here's who I want you to interview, I am not selecting them as unbiased people. I am selecting them to support me in my position.
Yeah. It's so if you're in your divorce case, if you call your mother as a witness, nobody's going to really care what she has to say. She might, she'll love you. She'll say that you're a great kid. She'll say that, you're the best son or daughter that anyone could ask for and support your position because that's what people expect her to say.
Yeah,
And 9 times out of 10, that's what she's going to say, unless she comes out and says, "Oh no, actually, my kid's a horrible person. I failed. It's my fault. I failed as a parent, and you should give custody to their spouse." Then people may want to hear that, but
yeah. Well, maybe what you do is you look at their mother-in-law instead of their mother.
yeah,
So,
yeah,
but okay. So we've got this information now, and that gives me a great deal of information to begin considering and ferreting out as I make conclusions about the parental systems and how they may cooperatively work or how they may choose to try to undermine the other person. Who might be the better person, depending on the type of custody, whether I say we need a joint custody, whether we say we need an independent custody, you know, uh, you know, there's a lot that's taken into consideration that comes out of it. But then I've got to evaluate the child too, you see. And so we're looking at the same biopsychosocial, the biological, depending on the age of the child, I may take from parental report and a medical report. If I have a child that's old enough, the child can tell me some about their physiology. Okay,
yeah.
now,
If you had like a child who had like a chronic condition, how each parent manages that would be of importance to the custody evaluator. Or if they find out that the kid's always going to the emergency room on the parents' time, and either there's nothing there or there is something there, that would be important to know as well.
Definitely. Those are very good points, Braxton. And then we look at the psychological piece. Where do I get that? There are developmentally appropriate assessment methodologies. And in fact, one of them even may be the school teacher. They may not be, an MMPI, but you're not going to give an MMPI to a child. In fact, they're really not designed for anybody who is younger than 18. Um, but there are some child types of things, um, some assessments that we okay to use. The child give you some information. Okay, so the sociological comes from them. You're observing their social interaction. You're observing their teacher report. You may sit in a schoolroom for an hour. You may become what we call the fly on the wall and just become an observer. You may go into their home and observe um, what's going on. But again, you've got to spend some time to become a fly on the wall. You don't come in and just take the Velcro and hook yourself up on a wall and they ignore you because you're there. They know you're there. You've got to create a presence.
Yeah, you've got to become kind of part of the scenery. You've just
Exactly.
got to become kind of a fixture or an office plant,
Yeah.
you know?
Okay. So we get the biological, the psychological, the sociological of the child, and that gives me data on the child. Now, if the child's old enough, I get a child's report, on what's going on, how they interact with their parents and things like that. Now, so we get a developmental assessment, and this is a part that's very time consuming. One that is done in their natural home habitat. That's where I was talking about becoming the fly on the wall, so to speak. The other is in an observed environment, like behind one-way glass. And you've got to create the system for that. So you may have in the behind the one-way glass one set up where you've got the child, you've got one parent, and you give them some tasks that you have created for them to do that will give you information about how they interact, how they teach a child something, how they interact with that child to facilitate their relationship. And I like to do a joint one where I put both parents in, give them a task to do with the child. And what I find in that is I watch and see if one is more dominant, if one tries to be pushy. And again, I might have to take 3 or 4 hours to get them ready and acclimated and have them in that setting, not for 3 or 4 hours, but a total of 3 or 4 hours before they really start giving me evidence-based information.
Yeah, it would be important to correlate both of them because each person is going to give uh, their rose tinted view of what
Mhm.
is the actual like natural environment. So
Yeah,
each parent is going to try to come off as the best parent in the world, super mom or dad. And then when they become comfortable with you, you can actually observe to see who is actually super mom or super dad, or whether or not they're just trying to put their best foot forward. And then you're able to kind of find the cross section of both of those.
yeah.
So
And taking your term super mom, super dad, I would look at it, and that's a great way of saying it to people. I look at it in terms of attachment. Who and how is the attachment process happening with this adolescent, with this child, with this infant? You know, I'm watching for that attachment phenomenon. I may even take an older child and a parent out and say, okay, teach your child how to catch a ball.
yeah,
Okay, what am I seeing in that? One,
Yeah, if they're incredibly awkward, like they've never really had this kind of interaction before, that's telling.
yes. And so what hopefully what you're seeing is I don't stick to just one environment.
Yes,
I've got to be able to transcend the typical clinical, we stay in my office, we do this and this and this and this. I've got to be able to transcend that and be able to use what I feel is most helpful in acquiring the information that I'm responsible to acquire. Okay?
absolutely. Yeah,
So
because
I'm,
otherwise
I'm
you're just
then,
checking
whoops,
boxes.
yes. So here I've got then the parental relationship and attachment data. I've got that information. So I create now my report. Now, my reports are typically quite lengthy. They may be 200 pages, single spaced, but I organize it in a way that I hope is helpful to the court. I begin with my introduction, which says this is what I was asked to do. These were the objectives. It's all laid out there. Then I tell them the conclusions and the recommendations. I go through a relevant review of the literature because there are things that I want to be able to say, this has evidence base to it, and this has evidence base to it. So I look and I have to take time to review the literature. Okay. Then I present that. I present the methodology, just like what I've done for you, Braxton. I have actually presented the methodology that I use to collect data to make a decision. Now, I realize it's been kind of fast and simplified, but that methodology, I share that. So people can look at that. You as an attorney could look at that and say, oh, I can see how he's gathered that information.
Yep.
Then I go ahead.
Well, I was going to say, because that's going to be one of the avenues that if, say, somebody wasn't happy with the custody report, that's an avenue that their attorney would take to try to discredit the report by
Mm-hmm.
saying it would be the difference between, like, if you've reviewed the relevant literature methodology, saying this is the test that was conducted, this is what the literature says about, this test and these behaviors, this is
Mm-hmm.
what I observed, and so this is the conclusion that I draw, as opposed to somebody, a custody evaluator that wasn't as thorough just says, well, I found evidence of this.
Yes.
Okay,
Yes.
what does that mean? What does that look like? How did you find that?
And I have reviewed some evaluations where they don't include this. They give you the conclusions and recommendations, but I don't know where in the world they got it. And that's a problem for me. And if I go back
Yeah,
and ask for it, some are good and able to clarify it. But I think that should be up front. Why
yeah,
should there be an added expense uh, for me to come in? And my fee is not easy, you know? And
yeah.
so
They're
you get,
expensive.
yeah, so then you get the analysis of the data and the discussion of the findings. Now, you might say, well, that sounds like a research article. And I'm going to say, you're absolutely right, because
Yeah.
my mind thinks in that kind of a scientific manner.
Well,
And then,
it should be. All of the reports should be in that kind of scientific manner because you're evaluating something. You're doing an evaluation. You wouldn't want somebody to just kind of rock up to the courtroom day of and say, yes, I didn't give you my report, but believe me, just believe everything I have to say. I'm an expert.
yeah, I'm your expert witness. Well, I've learned in years of being an expert witness that uh, you're not an expert until you've really proven yourself to be an expert. Okay,
Yeah.
so, I had a judge say to me, Openshaw, can't you simplify these reports? And I said to him, Your Honor, I'm giving you the simple version of the conclusions and recommendations, but I really encourage you to look and see how I found them, how I got there. And they've been very appreciative of it. And so The conclusions and recommendations are noted again. And that's Braxton the report. So what you've heard today are things that are people are already doing, and hopefully things that if they're not doing, they want to add to their practice. And,
Yeah.
you know, I just want to thank you, and I want to thank Eric, and I want to thank others. You know, anybody who even wants to take the time to listen to this. I hope that it maximizes curiosity and minimizes the negative impact on children.
I think these will. So wonderful.